Good evening, everyone. Hope you all are doing well. Welcome to the 17th webinar for Super 100 webinar series under the aegis of LIC AMR. I will be the moderator for this session with Rukmani. The topic which we intend to cover today is transparency in international arbitration, publication of arbitral awards versus data protection. And to discuss on the same, we have with us Ms. Dolera, who is a tri-qualified arbitrator and solicitor in England and Wales, attorney of law at New York State, USA and the Philippines. She has also authored a book on arbitration volume in Halsbury Laws of Singapore in the year 2018 and 2020. Thank you for joining us today, ma'am. The structure for the
Thank you for having me.
The structure for the webinar will be as follows. First, we will discuss the introductory remarks for 15 to 20 minutes. Then we will discuss on subtopics related to the main topic, followed by the concluding remarks and F&Q session from moderators and participants. Shall we start, ma'am?
Sure.
Yes, ma'am. Please start with your introductory remarks.
Okay. Good evening, everyone. Yeah, it's nighttime already here in Singapore. So today, as Bhavya mentioned, we'll be discussing about transparency in international arbitration. That would lead us to talking about publication of arbitral awards versus the requirements for data protection and confidentiality. As you know, in international arbitration, perhaps 20 years ago, what the arbitral institutions have been talking about was when to use PDF documents. And that was the main issue at the time. But now, with the widespread use of technology in international arbitration, we have to grapple as well with issues arising from confidentiality and data protection. In international arbitration proceedings, most of you might have already attended arbitral proceedings. It's fully conducted online. And most of the time, if not all of the time, especially these days with the pandemic and all, where travel is restricted. So even the hearings are done online already. So we don't normally meet the parties or the arbitrators in person. Everything is done online. So we go to the first slide in manner of conducting. Yeah. So all these are being conducted via email and other electronic communications between and among the parties, the arbitrator, the arbitrators, and the administering body. When I say administering body, the arbitral institution administering the arbitral proceedings, that would include SIAC, LCIA, ICC, and the like. And we also have to make use of storage of information. As you know, in arbitral proceedings, we handle a lot of data on a large scale, especially if the chambers or the arbitral institution is administering hundreds and hundreds of cases. So we also have to use storage of information devices where the parties and the tribunal has access to. This could be portable or this could be fixed. A lot of arbitration proceedings that I've attended use flash drives for the arbitrators, in order to avoid internet unpredictability in various jurisdictions. But a lot of these proceedings also use cloud-based storage, so that wherever the tribunal members would travel or the counsels or the witnesses, everyone would have an access to that storage of documents, the evidence, the witness statements, expert reports, and everything. All the documents that's relevant to the arbitration proceedings. And then we also have to use software and media to present the parties' respective cases. Whenever we have the first day of hearing, counsel would have opening submissions, put in an online presentation of the cases with all the graphs and evidence referred to in those submissions. And then we also have the hearing room technologies, especially now that almost all arbitral hearings are done online already. So we have the video conferencing, multimedia presentations. We have to also grapple with the use of translations from the translators and real-time electronic transcripts from the various providers that's contacted for an arbitration proceeding. And what are the data privacy and confidentiality threats given these widespread use of electronic communications or software media use, the use of technology in international arbitration? Next slide, please. We recall a time where the Permanent Court of Arbitration's website was hacked sometime in 2015. Okay, it was during a maritime border dispute, a very sensitive one, between China and the Philippines. At that time, the website was implanted with a malicious code that posed a data breach risk to anyone who visited a specific page devoted to the dispute. And we also have hacking of internal IT systems of law firms. There was one survey that was done by a cybersecurity consulting firm named LogicForce. They surveyed 200 law firms, and these were their findings. I'll just go through the main findings. 40% of the law firms surveyed were unaware of hacking attempts in the internal IT systems of law firms. 95% of these law firms were not fully compliant with their own data governance and cybersecurity issues. And only 23% had adequate cyber attack insurance policy. And I also would wish to highlight the case of Libanco versus Republic of Turkey. In this case, Turkey presented evidence, and Turkey admitted that it obtained the evidence by hacking in a separate criminal investigation. They intercepted around 2,000 of the claimant company's privileged or confidential emails through the rubric of government surveillance. In that case, it was not said to be unlawful because it was an exercise by the state of its sovereign right to counter criminal activity. But the court eventually ruled to exclude such evidence from arbitral proceedings with a very long and thorough comprehensive analysis why it was decided so. And then we go to two recent cases that was discussed quite recently, just this year and late last year. And understandably, they are both investor-state arbitration cases. So they are cases against the state, cases filed by an investor against a state arising from a treaty. So we have, first, we have the Tenant Energy versus Canada. It's a case arising from the NAFTA, North American Free Trade Agreement. And the other case is the Elliott versus Korea. It's a case arising from the Corus FTA, or the Korea-US Free Trade Agreement. Okay. We won't go into the merits of the case because these are still ongoing cases. They're still going through the procedural process, the process of the arbitration, leading into the merits phase where you have the hearing, where you have the witnesses and the experts. But one of the issues that was raised during one of the procedures in Tenant Energy versus Canada, the parties made submissions on the potential application of the GDPR. The GDPR is the European Union General Data Protection Regulation. It cannot be argued, I think, in my view, that it's one of the more stringent data protection laws and with a very high penalty for non-compliance. So the parties in Tenant Energy made submissions on the potential application of the GDPR in the arbitral proceedings. One of the reasons was the nationality of the arbitrator. One of the arbitrators, there are 3 arbitrators, so one of the arbitrators is a UK national, and that was before Brexit. And therefore, having an arbitrator who is a UK national, the arbitral proceedings should fall under the GDPR. The tribunal's decision If you want to check in your leisure time, it's at the PCA website. It's called Procedural Order Number 2. The tribunal's decision said that an arbitration under NAFTA, the North American Free Trade Agreement, is a treaty to which neither the European Union nor its member states are party to. So therefore, the GDPR, the arbitration does not presumptively come within the material scope of the GDPR. Presumptively is a good word to use because I think the tribunal might be expecting more issues to be raised as they go along. They go through the disclosure process, discovery process of documents, so more and more documents would have to be, and personal data would have to be grappled with by the tribunal in this case. Under the Elliott versus Korea, the state argued that the Korean Personal Information Protection Act applies to the case, and it is required to redact. Under the PIPA, it is required to redact personal information from filings in the arbitration. For those of you who've been in a full-blown, complete arbitral proceedings, there's a lot of personal data that could be found within those filings. You know, personal data of lawyers, personal data of counsel, of arbitrators. Some arbitrators use their personal addresses, you know, for hard documents, hard copies of documents to be sent to. Then, of course, you have the personal data of witnesses, of the experts. So there's a lot of personal data involved. In contrast, Elliott argued that they are in favor of full publication of documents in this case because to them, in their view, the PIPA did not apply in the case at hand. Remember, the Korean PIPA is a domestic data privacy law. As you compare that to the GDPR, which is a regional European Union law. And there are also domestic laws within each of the member states of the EU. So going back to the tribunal's decision, and you could, again, if you have time, you could check procedural order number 4 in this case. Under this case, you could check how the parties argued and, you know, have a better view as to, you know, how to argue data protection issues. So this case, the arbitral tribunal sided with the Korea state, South Korea, and accepted that PIPA extended even to information that was already in the public domain due to prior disclosure by the media. In particular, the arbitral tribunal held that it was bound to apply Korean law on this issue. So therefore, the tribunal decided to grant the application of the state of Korea to redact some parts of documents to be disclosed. Again, please note that these cases are investor-state arbitration cases. These are not international commercial arbitration cases. We'll go through the differences and the difference in approach for data protection issues later. So we go to the transparency requirements in investor-state arbitration first. There is a general recognition of a greater transparency requirement for investor-state arbitration. That is widely and common knowledge for arbitration practitioners. Why this is so? This has been, the general recognition has been affirmed by the enactment of the United Nations Convention on Transparency in Treaty-Based Investor-State Arbitration, which came into force on 18 October 2017. This is more popularly known as the Mauritius Convention. Under the Mauritius Convention, the parties in an investor-state arbitration or in a BIT or treaty-based arbitration are required to disclose names of the parties, economic sector, and the relevant treaty involved. They're required to disclose all statements, all submissions by the disputing parties, the investor and the state, and even the non-disputing parties or third parties. They could come in the form of an amicus curiae brief, third parties whose rights will be affected with the way the tribunal will be deciding in these cases. You know, there are, so that's the Mauritius Convention for you. Upon request, witness statements, expert reports, and such other documents so requested could be disclosed under the Mauritius Convention. And it's also part of the Mauritius Convention that arbitral hearings are open to the public. Okay. There's one exception, an all-encompassing exception for this requirement to disclose, for this requirement to be transparent. And I wish to highlight that to you. Exception is confidential or protected information, and any information which, if made publicly available, would undermine the integrity of the whole arbitral proceedings. So remember that, would undermine the integrity of the whole arbitral proceedings. What's the rationale for these transparency requirements? First, investor-state arbitration is against a state. It's against a country. And if it involves a state, it necessarily involves public interest as well. And if the state will be made liable, or will be held liable for the claimants or investors' claims, who will be paying? Who's paying for the amount of damages that would need to be paid to the investor or the claimant? This would come from public funds, and these are usually from taxpayers, right? So that's the rationale for having these, the Mauritius Convention promote more transparency in investor-state arbitration. So publication of the awards as well is the norm in investor-state arbitration. But just a caveat, the Mauritius Convention, while in force since 2017, there are only 23 states had signed the Mauritius Convention, and 6 had ratified. As most of you international law geeks out there, signing is different from ratification. So only 6 had ratified the Mauritius Convention. To put in some perspective here, if all those signatories, the 23 states, were to ratify the convention, the applicability would cover a total of only 26 bilateral investment treaties. And at present, there's approximately around 2,300 plus, maybe 2,400 plus now in force globally, BITs globally. So if there are only 26 BITs covered under the Mauritius Convention, then there's only compulsory application of the Mauritius Convention to 1.1% of the BITs. So that's something that transparency obligation in ISDS cases would have to grapple with. It's not as popular as the New York Convention, where it's now nearing universal application with 160 plus signatories or ratifications as well. Let's go to the transparency requirements in international commercial arbitration. As you might already also know, international commercial arbitration is the private type of arbitration. We don't see that many awards or procedural orders that could be found online. There are confidentiality obligations in international commercial arbitration, and it's usually just between 2 companies from different countries, or an individual suing a company, or a company suing its former top management employee. So this include the scope of international commercial arbitration. So this is a private dispute resolution mechanism. But in the past 10 years or so, there's been a clamor for more transparency in international commercial arbitration as well. So the arbitral institutions, the major arbitral institutions, came up with a rule for publication of awards. But as you might see in the slide, it's subject to the consent of the parties. We go to the HKIAC, they would only publish awards if it's with the consent of the parties. SIAC and LCIA, consent of the parties and the tribunal members. Why include the tribunal? Of course, because the awards set out their own decisions, and it would show the way they think, the way they grapple with certain issues. So they need to know as well, or arbitrators need to consent as well, whether these arbitral awards would be published. And besides, again, as earlier mentioned, there's a lot of personal data into these awards. The addresses of the tribunal members will be there. Witness statements referring to emails made by witnesses would also be there, you know, if these emails are relevant to the way the arbitral tribunal has decided on the case. I wish to highlight the practice under the rules of the ICC, the International Chamber of Commerce. They have an opt-out mechanism. For the ICC awards made from 1st January 2019 may be published. But any party before publication could object to the publication or require that the published version of an award be anonymized, or pseudonyms may be used. If a party objects to publication, then the award will either not be published or will be published in a restricted format. So there will be redactions and all that. So it's an opt-out scheme, an opt-out mechanism. ICC says it will publish until and unless the parties object to the publication before, you know, before ICC publishes the award. There's a practical tip as well in one of the practice notes or in the guidance notes of ICC. It says, if there's a confidentiality agreement in place covering the arbitration or the specific aspects of the arbitration of the award, publication of the award will be subject to the party's specific consent. So this time, it will be opt-in for publication rather than an opt-out mechanism. So if you have an ICC-administered case, an ICC-administered arbitral proceeding, this would be a practical tip if you are, as a counsel, value the confidentiality, the confidential information, or your client would rather have the confidential information be kept private. So have a confidentiality agreement. So as you will also know, in international commercial arbitration, it's not treaty-based, but it's based on the contract between the parties and the disputes arising from that contract. And one of the foundational principles in international commercial arbitration is party autonomy. Right? Parties have always the last say. Parties have the say as who to appoint as arbitrators. Parties have a say as to where to have the arbitration, the place of arbitration, the seat of arbitration, the law of the contract, the law of the arbitral proceedings, and all these other factors that govern the arbitral proceedings. So parties have the last say. And parties could agree in their contract to keep the arbitral proceedings confidential, all aspects of it. That would be part of a confidentiality agreement. But I wish to highlight that confidentiality provisions are also provided for in the arbitration acts in various jurisdictions. So it varies from jurisdiction to jurisdiction. Let's take examples. The English Arbitration Act, it's silent on confidentiality, but it says that arbitration proceedings must be held in private. Okay. The way it's worded, must be held in private, please take note because we will discuss that later as we go through the conclusions of the concluding remarks. Implied confidentiality, therefore, under the English Arbitration Act is implied. Confidentiality is therefore implied in every arbitration under the English Arbitration Act 1996. There's only a few states or countries who have expressly provided for confidentiality obligations in their arbitration acts. These include India, New Zealand, Norway, Spain, Romania, Peru, and the Philippines. I'd highlight India, especially the India's Arbitration and Conciliation Amendment Act of 2019, which last year. If you wish to check it, it's section 42A. It places the onus of confidentiality on of the arbitral proceedings on the arbitrator, the arbitral institution, and the parties. My question is, what about the witnesses? What about the experts? Translators who are there, the transcribers who are there at the arbitral proceedings. And the India's Arbitration Act as well maintains confidentiality of all arbitral proceedings except the award, where its disclosure, the disclosure of the award, is necessary for the implementation and enforcement of award. As you know, once you have the arbitral award, if you're the winning party, then you go to the court of enforcement. So for example, if you've won an arbitral award seated in Singapore, but the assets of your respondent, the losing party, is in India. So you go to India, you go to the courts of India, have it enforced, apply for enforcement at the courts of India. So if it's at that stage, disclosure of the award will have to be necessary, so that the courts will have to see whether the award is enforceable or not. Singapore, there's an ongoing public consultation. If it has ended, it has ended already, but it's tabled in Parliament for an amendment to its International Arbitration Act. One of the proposed amendments is for a greater confidentiality obligation. So there used to be no, express provision on confidentiality. Singapore wants to propose an amendment to provide the arbitral tribunal and the courts with powers to support the enforcement obligations of confidentiality in an obligation. Okay, next slide, please. Parties, arbitrators, counsel, I think, in my view, most, if not all, value confidentiality in an arbitral proceeding. But there has also been criticisms against this confidentiality obligations. Why? As you know, the arbitral proceedings is just between two parties and the arbitrators. If none of the parties appeal or put any applications in the courts, then no one will know what happened, whatever happened into that arbitration. But if it reaches the courts, then people will know, how the arbitration was decided, were there any procedural errors and all that. So one of the critiques against confidentiality is that it impedes the development of common law, because we will never know how the arbitrators decided on those cases. And also, there's just a limited number of appeals of arbitration awards reaching the courts. Not all reach the courts for setting aside application or for refusing enforcement application. Another critique against confidentiality is the lack of consistency, certainty, and predictability. Because again, we lack the development of common law on international commercial arbitration. Okay.
Just hold a second.
Hello?
Hello. Could you just hold a second?
Hello? What happened? Okay. Shall I continue? Okay. And then lastly, a critique against confidentiality is the lack of transparency in dealings of arbitrators. So next slide, please. But despite this critique, most users or stakeholders of arbitration still prefer these confidentiality obligations to be upheld. So we go to data protection. How are they applicable to arbitral proceedings? Okay, I've chose 3 data protection laws: the EU GDPR, the Singapore PDPA, and the Hong Kong PDPO. Primarily because, number 1, EU is arguably the motherland, the birthplace of arbitration. And there's just quite a number, there's a lot of cases arising out of EU, a lot of arbitration cases arising out of EU. And because of its broadened scope, which we will see later on, that even if I have arbitration in Singapore, the arbitration here could potentially be covered under the GDPR. And then I also included Singapore PDPA and Hong Kong PDPO because arguably these two are the major hubs in Asia for arbitration. So first, we go through how these laws define personal data, because it's personal data ultimately that will be covered under data protection laws. EU GDPR, it's very brief. Any information which are related to an identified or identifiable natural person. I highlighted or made bold the term identifiable because I want us to compare that with the Hong Kong PDPO later. Singapore PDPA refers to data, whether true or not, about an individual who can be identified from that data. So who can be identified directly from that data. It didn't use identifiable. And B, from that data and other information to which the organization has or is likely to have access. The term they use is organization. We'll see later on why this is important. Hong Kong PDPO, current state, it's currently worded as directly or indirectly identified. They're not using identifiable, but there are ongoing reforms for a potential amendment of the Hong Kong PDPO. And they wanted to amend from personal data which relates to an identified person to personal data which relates to an identifiable person. Why is that important? Some personal data could easily directly identify a person. Okay, this is your name, this is the age, this is your gender, this is you. But there are also personal data that could trace and then identify indirectly and then be identifiable to a natural person. What are these? Your IP address, the behavior of the restaurants that you've preferred over the past 3 months, the behavior of monitoring your behavior as to the websites that you visited for the past week or so. So these are identifiable personal data. Next slide, please. And this is very important. The scope of the data protection law. Under the GDPR, as you can see, they define personal data very briefly, but their scope is very broad. A says activities of an establishment of controller or processor in the union, regardless of whether the processing takes place in the union or not. Two terms that I wish to highlight here, controller and processor, because a controller has different liabilities, different obligations and liabilities. A processor has different obligations and liabilities as well. Remember that the processing could take place outside the EU. So controller is based in the EU, processor is in Asia, covered with GDPR. Let's go to B. Processing of personal data of data subjects who are in the union by a controller or processor not established in the union. So even if the controller is in Australia and the processor is in Asia, but the data subject, us individuals, we are in the EU and we are not, it's not necessary that we are EU citizens, but we are in the EU, then GDPR would apply. Is that clear so far? For example, if I go to Europe for a holiday for 2 weeks, I'm not an EU citizen, and then I've been browsing travel websites, and I purchased tickets for museums using these travel websites, and the controller is based in the US, while the processor is based in Asia. I am in the EU traveling for 2 weeks only. GDPR could apply. Okay. Singapore PDPA, very direct. It does not contain an express provision on territorial effect. However, the PDPA is likely to apply for the collection, use, and or disclosure of personal data within Singapore, even if any remaining parts of the data processing takes place somewhere else in the world. So I think, in my view, the controller obligations are in Singapore, then it's covered under PDPA. processing if it could be outside Singapore. Hong Kong has a similar structure with Singapore. It uses the term data user. So data user for Hong Kong is the controller under the GDPR. Okay, next slide, please. Key entities, as we earlier mentioned, controller and processor under the GDPR. I don't expect you to be reading all of this. I will just highlight, what the main concepts are, because I figured some of you might want to have a PDF copy of the slides, so for you to read through. That's why I put in, the full provisions as well, some of the full definitions. So under the GDPR, you have the controller and the processor as the main entities. Just to highlight, controller, the natural or legal person, public authority agency. Remember, public authority is covered under GDPR. We'll take a look at Singapore and Hong Kong later. Public authority is not. And controller determines the purposes and means of processing. They are the ones who determine the purpose and the means. Whereas processor is the person, public authority agency or body which processes personal data on behalf of the controller. Okay. Singapore PDPA, they use the term organizations for controller and data intermediaries, concept similar to that of processors. I wish to highlight the last paragraph here, where a data intermediary processes personal data under a contract. It will be largely exempt from the PDPA, and it's only subject to two obligations, security and retention obligations. If you have time to go through to the GDPR, there's a long section for the obligations of the processor as well. But under Singapore PDPA, not so many obligations for the processor, but only security and retention obligations. Hong Kong PDPO, they use the term data users. The data users are the ones required to comply with the data protection principles, or the DPPs. A person who merely holds, processes, or uses personal data on behalf of another person is not considered to be a data user. Okay, so this is the processor, right? Processor under the GDPR. And I wish to highlight, processors have obligations under the Hong Kong rules, but they are set out in a non-binding information. Again, there's an information leaflet. Again, there are ongoing reforms being discussed for regulation of data processors. We'll see, let's wait and see. In the coming year or so, Hong Kong will come up with their amendments. Next slide, please. So key principles, all three, the cornerstone is consent. And before a data subject could consent, they must be notified. They must be informed. What are their rights? What is the personal data that could be collected? And what is the purpose? Why this personal data is collected? Under the GDPR, a legal obligation is also a purpose. For example, if you're the tax authority, then processing of personal data in order to process taxes, that is a legal obligation. Then legitimate interest of controller and legitimate purpose. Exemptions, personal or household activities, law enforcement to gather data for ongoing investigation, that is exempt. And of course, national security issues or concerns. Singapore PDPA, it's the same, consent, but they have this concept of deemed consent. If you've been, let's say, using a certain website already for quite some time, even without actively consenting for them to collect data, then you are deemed to have consented. Purpose is also a key principle in Singapore, and reasonableness. Exception, government agencies, not just law enforcement agencies, but government agencies. That's all government agencies and or organizations acting on behalf of a public agency. Hong Kong PDPO, the same. Let's go similar to Singapore. Let's go to its exemptions. As you know, exemptions from use limitations and access requirements, and perhaps also a springboard for all the security issues that Hong Kong has experienced. So it's exempt if it's for the purpose of safeguarding Hong Kong's security, defense, and international relations, crime prevention, or detection. And prevention of unlawful or seriously improper conduct. Legal proceedings is also exempt. One issue that arises with this legal proceedings exception is arbitration considered a legal proceeding? That's also an interesting issue that we need to look out for. Next slide, please. Because we already live in a world that processes data on such a large scale. So these laws also provide for provisions that restrict transfers to third countries, so that it will not just be on all-encompassing, no holds barred transfers to third countries. Under the GDPR, it's the most stringent. First step, it needs to have the consent of the data subject, and only for the authorized reasons of fulfilling a contract and protecting vital interests. But there has to be a second step. It has to be shown that the transfer to the third country is permitted. How is this permitted? You have to go through a European Commission assessment. It has to be assessed by the European Commission, and the European Commission comes up with an adequacy decision. Adequacy decision, if it's granted, then that country is deemed to have data protection laws on par with the GDPR. So these are the list. This is the list of countries with an adequacy decision. And currently there are ongoing adequacy talks with South Korea. Singapore, Hong Kong, there's a limitation for Singapore. The transfers will be allowed when made in accordance with the requirements in the PDPA. You have to apply for exemption for this one. So similar to the GDPR. It's just not more expressly worded. Hong Kong, there's no restriction, but there is a section 33 in PDPO, but it has not come into effect. I don't know why. Sometime in December 2014, the Privacy Commissioner issued a non-binding guidance note regarding transfers to third countries. Next slide, please. And this is I think, in my view, the reason for the hype, especially for the GDPR. You can see the numbers there. It runs into the millions. Penalties for non-compliance. Okay, not so serious. It's serious infringement for not having records in order, not notifying the supervisory authority, for breaches. So the administrative fine would be up to 10 million euro or up to 2% of the total worldwide annual turnover, whichever is higher. You go to B, it's for the most serious infringement, not having sufficient consent. See, again, consent is the cornerstone of the GDPR. Not having sufficient consent to process data or violating the core of privacy by design. Is this okay? There are certain arrows in the PowerPoint slides. Bhavya? Anyway, so Singapore.
That may be technical issue.
I'm sorry?
That may be technical issue.
Okay, no worries. Under Singapore, financial penalty of such amount not exceeding $1 million, Singapore dollars. And then Hong Kong is the less onerous one. Fines of up to Hong Kong 1 million, which is equivalent to about US 130,000. But take note, there is imprisonment for up to 5 years. GDPR, PDPA, Singapore, no imprisonment, but Hong Kong has imprisonment. There are ongoing reforms, again, for Hong Kong PDPO. There are proposed amendments that includes Privacy Commissioner proposing administrative fines to be linked to the annual turnover of data users. So what are the potential implications? We go back to tenant energy versus Canada. Again, these are investor-state dispute settlement mechanisms. It's against the state. As you see, the arbitrators just decided GDPR does not apply because this is a NAFTA case. They did not even consider the other broad extraterritorial scope of the GDPR, as you've seen, right? Even if there are no EU citizens in the case, GDPR could still apply. Number one, the arbitral institution administering the case is the Permanent Court of Arbitration, PCA, which is headquartered in the Netherlands, which is in the EU. That could be a potential hook that the GDPR should or ought to apply in this case. Sorry? Hello? Okay. And then, another potential issue is that PCA is considered an international organization under public international law principles or concepts? If so, is it immune from the GDPR? In this case, potentially the arbitrators are the controllers, the PCA would be the processor under the GDPR. In Elliott versus Korea, while it involved a domestic law, the PIPA of Korea, if you look at the website and the information that's available regarding this case, one of the arbitrators is from Finland, which is part of the EU. Can the parties now submit that GDPR should also apply in this case, right? If one party submits that GDPR is applicable and Korea insists that it should be PIPA that should be applicable, how will the arbitrators grapple with that issue? That would be interesting to see if indeed both, conflicting or various data protection laws will be submitted on in an arbitration case. And then we go to the Mauritius Convention, the requirement for transparency. Can it be applied together with data protection laws? Transparency versus less transparency via the data protection laws. In my view, yes. A practical point would be to provide for a confidential agreement set out in the BIT. That's what happened, I think, in Elliott versus Korea. The BIT sets out a confidentiality agreement. The parties determined, and agreed on what confidential and protected information would consist of. So early on, they know what would be confidential and protected information. Next slide. So what is the current status and what are the issues to be addressed moving forward? One, confidentiality obligations is clear. They're set out in the State's Arbitration Act. If an arbitration is seated in the state, then those confidentiality obligations must also apply. But however, data protection and privacy, since it's still just like a growing minefield of issues, there will be a lot of tricky issues to grapple with. First, general concept of privacy in arbitration is different from privacy under data protection laws. This need to be harmonized. Privacy in arbitration is simply, keeping the arbitral proceedings private. Whereas privacy under data protection laws would include what? IP addresses, personal data that's found in the written submissions and in the awards. Second, how do we determine which data protection law to apply? So as mentioned in as earlier discussed in Elliott versus Korea, they have an arbitrator who's from Finland. So potentially GDPR could apply, but Korea submitted on that the domestic law, privacy law of Korea should apply. So how do we determine which one should apply? Should it be a regional law, GDPR, or domestic law? If domestic law, which domestic law? Which regional law, if regional law? As you know, in arbitral proceedings, you have to grapple with a lot of laws. You have the law of the seat of arbitration. I assume everyone has already like a brief background perhaps on arbitration. You have the law of the seat. You have law where the administering arbitral institution is located and its relevant rules of arbitration. You have the law of the claimant of the respondent's establishment or domicile. You have the law of the place of the hearing, which I think is quite tricky in India. Law of the place and law of the seat of arbitration. And of course, you have to also consider the treaty upon which the arbitration is based, bilateral investment treaty or a multilateral treaty. And also consider the law where an award is to be enforced. So there's a lot of questions. I know there will be a lot of questions in your mind because this topic is really ripe for a PhD dissertation. More research should be done for this part of the topic. So I ask myself and I ask you, is it just a hype, all these data protection, issues and paranoia, or is it time to take a proactive stance? I would argue the latter. I would submit on the latter. It's time to take a proactive stance because we don't want to wait that there will be a data breach. It will only take for one person to complain for data breach, and it could potentially come up with liabilities in the millions. So in my view, arbitral tribunals and arbitral institutions must take a proactive stance and come up with a data protection agreement, perhaps at the initial stages of arbitral proceedings. And that would effectively structure the proceedings to protect personal data from data breaches as they go along the arbitral proceedings. I think it's ripe for questions if you have any questions. Bhavya?
Earl, thank you so much. You have imparted the best of your knowledge to me, my co-moderator, and the participants as well. So I'll ask you 2 to 3 questions which I have in mind after you showed your PPT.
Sure.
Yeah. So my question to you is that do data protection laws enhance the role of venue in remote arbitration hearings?
Sorry, venue and?
Remote arbitration hearings.
For international commercial arbitrations, confidentiality and privacy of personal data has been more protected than, there are more, we don't hear of such cases of data breaches in international commercial arbitration cases. With virtual and oral and online hearings, it's more protected because, in my view, because we have professionals taking care of all the submissions in electronic format. These are professional companies whose sole job is to protect and gather and protect all these documents and then data that comes with all these documents. I hope I answer your question.
Yeah, you did. Thank you. So I'll move on to the second question. My second question to you is, just a second. Yeah. So recently in LCIA Arbitration Rules 2020, which came into the picture, the Article 30A of the same talks about the data protection. So what are your views, and will there be transparency in international arbitration? If yes, then to which extent the transparency will be there?
You mean international commercial arbitration, transparency in international?
Yes.
The transparency in international commercial arbitration will still be limited to the publication of arbitral awards. That requires consent from the parties and the tribunal members. The data protection rules, I hasten to add to my presentation that, as I mentioned, arbitral tribunals and arbitral institutions are really at the forefront of data protection in arbitral proceedings as we speak. And arbitral institutions are really in the position to come up with rules to incorporate data protection. Because there's still no precedent, no cases having analyzed all the issues that could be raised under the data protection laws, it would be prudent to follow model clauses that the arbitral institutions or model agreements that arbitral institutions would come up with. So I salute LCIA for doing that.
Thank you. You very much answered my question. So there is this question from Shreya Agarwal.
Excuse me.
She's saying,
I have few questions with ma'am.
Sure.
So ma'am, Whether there should be systematic publication of arbitral awards is not new, but it has received increased attention over the last couple of years. So my question is, should we embrace the systematic publication of arbitral awards?
Where did you have the systematic publication of arbitral awards? Is this the investor state arbitrations or international commercial arbitrations?
International commercial arbitration.
From which arbitral institution?
Ma'am, any, but international. Wide.
Okay, that's also I think perhaps that's what triggered Singapore to come up with a more robust confidentiality scheme. Because like, for example, just in my experience, we've had a commercial arbitration in India and in Nigeria before. And after a few years, we found the full award online. And it's a commercial arbitration. And it's supposed to be private and confidential. But without any specific provision under the law, no one could police those that have disclosed the arbitral awards online. I'm not sure if it's systematic. Is it systematic or systemic that you would mention? I'm just not sure where that comes from, if it's legal or not. But yes, it has been done, and it's just so unfortunate.
Okay, thank you.
Any more questions, Bhavya?
No, ma'am, not from my side right now.
Okay.
Hello.
Yes, I can hear someone.
If you want to ask a question, you could please chat in the type box. We just don't allow switching on the mics for the participants.
That would be more organized. So there's one question. You want to read it for all of us? Yeah.
There's a question from Shreya Agarwal. She has asked that how can we as students be able to attend online arbitration hearings? Is it allowed? If yes, what would be the procedure?
I would suggest investor state arbitration hearings that's found in the website of PCA or ICJ. That is widely available, publicly available. For international commercial arbitration, it would be difficult because again, it's privacy and confidentiality is foremost in the minds of the parties in these cases. So if you want, you could, if you know of someone who's acting as counsel or acting as arbitrator, then ask for his or her permission, and then they would then ask for permission from the parties in that case. But it will be difficult because not all would welcome, third parties or outsiders of the arbitral proceedings. Anything else?
Ma'am, there is one question in my mind that is it beneficial to promote the publication of international arbitral awards? And if it's the case, how such publication should be conducted in order to reconcile it with users' expectations?
In an ideal world, I would want publication of international commercial arbitration awards, but preferably redacted. Or what the courts in Singapore would also do is to use pseudonyms and just put out the relevant decisions of the arbitrators. No need to go through the whole procedural process where more personal data could be found. So just the analysis of the arbitrators, I think that's the most important part.
Okay, ma'am. Is there if any participant has questions, please type in the chat. We will take the question.
There is this question from Harshit. So he's saying that, hello ma'am, I want to ask that, like, ma'am is graduated from Stanford Law School. So what's the way to get into the Stanford? What is the experience which is required after completing our LLB from India and move to USA and study all the US laws and practice our litigation there?
So you're more interested in that than our topic for discussion. But I'm happy to address your queries. What's the way to get into Stanford? It needs at least you need to at least 2 years of working experience, and it's difficult to get in if you have no working experience yet. And then I'm not sure if they've allowed or admitted students with no work experience, so long as the academics are just too stellar for words. So that would be an exemption. And there's a lot of us who have like more than 10 years experience in arbitration, in litigation, in corporate practice. And yeah, just be awesome at what you do, I guess. I'm just kidding. But yeah, just try. You never know. Do well in your studies. Have some work experience in the 4 specializations that they offer, which is law, science, and technology, or environmental law, or international economic law, and corporate governance.
I guess you must have answered Harshal Khatri's question, and I think there are no more questions, I guess. So I'll just end the discussion here, and thank you so much for imparting such a great knowledge about this topic. It was very helpful, and I think it was helpful for the participants as well. And we are looking forward to catch up with you sometime soon about really good topics, which include international commercial law arbitration as well, obviously.
Thank you everyone
so
at LegisNations. It's a Saturday, and you all have decided to learn something new, perhaps, with me. And I wish you all have a good weekend and safe passage in this pandemic.
Yes, same to you, ma'am. Stay safe.
Keep safe and healthy.
Thank you.
Thank you, ma'am.
Bye.
Bye.
Bye, ma'am. Thank you.
Bye.